I think it's just on 10 o'clock, so I think we can start. I hope everybody is out of the waiting room and participating in this webinar. Good morning and welcome. Thank you very much for joining us. For those of you who don't know me, I'm Jacques Blignaut. I'm a director at STBB in the commercial department. And I'm joined this morning by my colleague, Kelly Leach, who's a senior associate in our trusts and estates department. Welcome, Kelly. Thank you very much for helping on this. And I think just some housekeeping rules. You'll see that the webinar is being recorded. So I think you can get copies of it afterwards should you want to use it to fall asleep in the evenings. You can just pop it into your player and earphones, and it'll put you to sleep quite quickly. Then secondly, I think everybody is automatically muted. Please do not unmute yourself. It's very noisy and it hinders the people who want to listen. And our IT department has a whole collection of 1980 Sokkie treffers that will automatically be sent to your email address if you should unmute yourself, and it will play randomly at all hours of the day and night. So thank you very much. The topic we're going to look at today, ladies and gentlemen, would be piercing the trust veneer. It's a quick overview. By its very nature, this can only be a very, very high bird's eye view of the situation. We can probably devote several sessions to the details of the cases. So our purpose today is just to give you an idea, things to look out for, and then perhaps we can follow up at a later stage. So we will start at why we need to do this. Then we will look at the concept of piercing the corporate veil, refer to some cases on how it is done, and then we'll wind up by seeing if we can give you one or two tips on how to avoid your trust assets being added back into your personal estate or at the being put at the disposal or the use of your spouse that you never want to see again in your life. So I think the starting point for anything on trusts is just to clarify in our own minds, what is a trust? And here we're talking about inter vivos trusts. And it's important to remember that a trust, at the end of the day, is an agreement. Whereas corporate personality for companies and close corporations is founded by an act, the Companies Act in one case, and the Close Corporations Act in the other. For a trust, that is found in the four corners of the trust deed. And the trust deed is an agreement between, on the one hand, a founder or a donor, on the other hand, one or more trustees. And the agreement between the founder or donor on the one hand and the trustees on the other is quite simple. Here are some assets, and I'm placing them at your disposal. You need to administer these assets for the benefit of people that are beneficiaries. You owe them a duty to administer these assets to the best of your ability. Now, as you can see, because all the rights and obligations of the parties are found in this document, it is very important that the draftsman of this document must anticipate as many things as possible when he's drafting this document. He must formulate the powers that the trustees will have, how they can deal with the assets, and what they must do when, and what the procedure is that they must follow. Now, it's quite easy, and this is where the problem comes in, where you have a very simple trust, where A is the donor, B and C are the trustees, and E, F, and H are the beneficiaries. Then they not interfering with each other. But you all know that the normal family trust or business trust, as the Trust Property Control Act calls it, doesn't work that way. The way that trust, our normal trusts would work, is that you'd have one person, the donor, who would also be one of the trustees and one of the beneficiaries. So you can already see that the rights and duties are overlapping. The important thing, if a trust is properly formed and constituted, is one, the donor divests himself of the ownership of the assets. Two, the trustees become the joint owners of the assets in their capacities as trustee. So they need to follow all the rules of joint ownership at the end of the day when they deal with these assets. One of them being, one, they need to act jointly. If you're dealing with joint assets, the owners of those assets must act jointly. And the common law relating to trusts definitely bears that out, the requirements of our courts as well. And then secondly, and I think this is a very important point when one looks at today's topic, they are acting as principals. They are not acting as agents. They are principals. These assets are their assets, and they need to deal with them for a very specific purpose, being the benefit of the beneficiaries in a trust. Now, let's see if I've got the screen. I hope everybody can see the second slide. Now, why would one form a trust? And I think there may be very reasons. Kelly will tell you that we've heard some very strange reasons for forming trusts. But I think the two most important reasons would be, firstly, asset protection. That's where you want to ensure that certain assets are not exposed to the claims of your business or your personal creditors. So that would be investments, it would be immovable property, whatever it is, but you want to keep that away from your personal creditors. The second one, of course, is estate planning. And what does one want to do with estate planning? You want to take certain assets, mostly growth assets, and you want to take those out of your estate so that the growth in the value of those assets will not take place in your estate, but in the trust. And the beneficiaries are your descendants, then you achieve what we call generation skipping, where the assets will pass to the next generation without paying estate duty on the value of those assets on your death. Of course, trusts can also be set up to have other tax benefits, most notably in our example that we've now used, capital gains tax benefits, but we're not going into that now. So those are the two main reasons we identified for creating a trust. So of course, if you now get to a position where the action of either the donor, the trustees, or the beneficiaries puts these trusts at risk of allowing the court to peer behind the veil or the veneer of the trust, then this whole exercise has been futile and in most cases very, very expensive. So why now? Why is this a topic that we want to address now? And I think there are a few reasons. One is our favorite for everybody dealing with attorneys or your banks is FICA, and all the forms we have to complete. And I think what has happened is worldwide, there is a movement by governments and regulatory authorities to curtail money laundering and terrorist financing activities. And they are really trying to get the true owners of assets and the true sources of funds. And in order to do that, they need to go behind the structures where the identities of people or the assets themselves are hidden. Because South Africa is now on the grey listing as a result of the fact that our FICA compliance hasn't been what it should have been. There are several steps to establish in our law now who the ultimate beneficial owners are. You'll all be aware that as far as companies and close corporations are concerned, and also for trusts, there have been amendments to the Companies Act and the Trust Property Control Act to introduce the whole concept of ultimate beneficial owner. And those registers now need to be completed with Sub C for companies and closed corporations. And on the other hand, the Master of the High Court for trusts. And in the commercial department, definitely, and I think Kelly and them in the estates department, we often have to do with very, very complex structures where you really have to apply your mind to figure out who owns the assets ultimately, who ultimately benefits from these assets. And in many cases, trusts are used, and those trusts are situated in various jurisdictions. The second reason why I think this is becoming a topic that is more relevant is the fiscal position of especially our government. I think worldwide, you'll find that government finances are under pressure, and especially in South Africa. So the government is going to, and the revenue collection authorities in all countries are going to try to find ways of getting to the true owners of trusts and to tax the wealth where it is held. We believe that Kelly will speak about the Estate Duty Act, but the government is definitely going to use its resources to get behind trusts to see whether assets can be added back into the estate of people. Then the economy and economic pressures. We are all aware that consumers are really suffering. Businesses are suffering. I heard yesterday evening where they said that the big corporates in South Africa are sitting on approximately 1.5 trillion rand in cash that's not being invested. And they're only about 20% geared on their borrowings. For smaller businesses, they are probably around about 100% geared with no cash resources. So you can imagine that for smaller businesses, the economic pressure is on, as for individuals. So we've already seen that there's a rise in insolvencies and in liquidations. And definitely the trustees of insolvent estates will try and get to assets in trust to add them and take them back into the insolvent estates for the benefit of those insolvent creditors. And then the other one that is quite interesting is matrimonial matters, where in the past 2 decades, there has been a move for people to attack trusts to see if the assets held in trusts can be taken into account in redistribution orders that the court can make in terms of Section 7, subsection 3 of the Divorce Act, and also whether assets held in trust can be taken into account in determining the accrual in a party's estate. And we believe that these claims are going to become more prevalent in matrimonial litigation. If my partners Shireen or Shanae are tuned in here, please, you can tell us, Shireen, Shanae, whether you are seeing it already happening, especially given the judgment on the Constitutional Court, I think about 2 years ago, where the Constitutional Court removed the time clause in Section 7.3 so that redistribution claims can now also apply to marriages out of community of property concluded after the date on which the Matrimonial Property Act came into being in 1984. Now, piercing the veil. Piercing the veil is a term that we use to look, or that the courts use to look behind the separate personality of an entity to see what actually happens behind the scenes. It's not a term that our courts are unfamiliar with. They've used it over the years. They've developed common law in that regard. And the legislature has also pitched in, especially with companies and closed corporations. In the case of companies, Section 20, subsection 9 of the Companies Act provides that if a court finds that the incorporation of the company, any use of the company, or any act by or on behalf of the company constitutes an unconscionable abuse of the juristic personality of a company as a separate entity. So the court recognizes a separate entity of the company and says that's being abused in an unconscionable way. The court may declare that the company is to be deemed not to be a juristic person, so no separate personality, and in respect of any right, obligation, and liability of the company or of a shareholder or a non-profit company, a member. And the court can then make any further order that it deems appropriate to give effect to that declaration. Now, the courts have here sort of found that an unconscionable abuse is where, the conduct of the directors and the managers of the company is of such a nature that you can't distinguish between them and the company. In the case of Gore, there was a whole group of companies, and it was basically run as one company. I'm thinking of 5 or 6 or 7 companies, but basically it was run as one company. And the court held that it was a chaotic administration of the companies and that they should be treated as one. Of course, you'll all be aware that in the Companies Act, there are also provisions for holding directors personally liable. That, I submit, is not piercing the corporate veil. That is really just a basis for getting to directors for breaching their fiduciary duty towards the company that they serve. Section 65 of the Closed Corporations has a very similar provision, except the court there must find that the activities constituted a gross abuse. So it's not an unconscionable abuse, but a gross abuse of the juristic personality. And funny enough, we'll discuss the concept of alter ego a little bit later, but the courts have held that as far as closed corporations are concerned, they introduced the concept of an alter ego where the member treats the company assets as his own, and the company or the CC becomes his alter ego. And the member then uses those corporate assets for private ends. Now, that's when we work with the corporate bodies that are recognized by statute, companies and closed corporations. When it comes to trusts, the courts have developed 2 concepts that we just need to look at. The first one is the concept of a sham trust. And I think the name says it all, and the courts have held that in some cases there isn't really a trust. But people are using the concept or the facade of a trust to hide their actions behind. And the assets really belong to somebody else. And in this case, the trustees are merely carrying out that person's wishes and acting on his or her instructions. And the important thing that the courts have found here, and it goes back to what we said earlier, that in a properly constituted and managed trust, the trustees are acting as principals. The courts have held that in the case of a sham trust, the trustees are in fact not acting as principals, but as agents for somebody else. And one of the questions that the courts would look at when deciding whether the trust is a sham trust is whether this trust was properly formed. So, for instance, if you get to a situation where a trust wasn't properly signed, it wasn't formed. And I'll talk about one or two other aspects a little bit later. But if the trust wasn't properly formed or it doesn't exist, it's a sham trust. The concept of an alter ego, on the other hand, the court recognizes the existence of a valid trust. And the court says, we've got a trust. The trust is the owner of the assets, but the way in which this trust is being used or managed gives us the idea that it is in fact just the alter ego of a person who actually controls the trust assets at the end. Now, that can be the donor, it can be the trustees, one or more of the trustees, and it can even be a beneficiary or a third party. So, I mean, what becomes important here is whether the assets of the trust and the way in which they are being managed is still for the benefit of the beneficiaries or whether it's for the benefit of somebody else. And if one looks back at what the courts held in the case of close corporations, where the courts have said that where it's being used as an instrumentality and the corporate assets are being used for private ends. So you find that the trust here is just being used as an instrument for managing the assets for the private ends. So what are the remedies that are available to the courts? I think if we can just look at that quickly. On the insolvency of a person, if it can be established that assets that fall outside his or her estate and fall in a trust, which is either a sham trust or which became the alter ego of the insolvent, then the trustee of the insolvent can go behind this veneer and bring those assets back into the estate of the insolvent, where they can be sold and the proceeds distributed for the benefit of the insolvent's creditor. On the termination of a marriage, the courts can order a redistribution in terms of Section 7, subsection 3 of the Divorce Act, if they find that either it was a sham trust or that the trust was the alter ego of one of the parties to the divorce. And in terms of the Matrimonial Property Act, the court can then take into account those assets in such circumstances in calculating the accrual of a party. Now, it's not entirely clear always what the courts will do once they've found that, because in most cases they'll only take it into account. But if there probably won't be enough assets in the estate outside of one of the parties to a divorce's estate to give effect to the order, the court can even order that those assets be sold and the proceeds be applied to giving effect to its order. So it can order the distribution. It's got a very wide discretion. However, in terms of the calculation of the accrual, where the courts get their discretion in terms of the Matrimonial Property Act to determine the accrual in an estate, that is a far narrower discretion. The court cannot order a redistribution there, obviously, but they can take it into account in calculating the estate. And in one or two of the cases, the courts have even gone so far to say that even if a party only has the benefit of assets, the value of those assets can be taken into account. And then, of course, if the beneficiaries or third parties suffer damages as a result of the actions of the trustees or the parties standing behind the veneer of the trust, the court can also make orders to hold them personally liable. Now, in order to illustrate the development of this, I'm going to hand over to Kelly for a while. She's going to talk about matrimonial property. And then between the two of us, we're going to discuss one or two cases to just show you how the courts develop these concepts. And then it will end off by looking at the principle, if we can deduce any principles from that, and how you can protect yourself. So, Kelly, I'm handing over to you now.
Good morning, everyone. I hope that everyone's doing well. You can all hear me. For today's purposes, we're going to be looking at two specific marital regimes. The first being that of community of property, and then, of course, marriages out of community of property with the accrual system. As most of us know, community of property is the default marital regime in South Africa. This is where spouses are married and their separate estates become one joint estate. All of their assets and all of their liabilities are brought into one estate, whether it existed prior to the marriage or whether it came about during the subsistency of that marriage. On the other hand, we have marriages out of community of property with the accrual system. And the accrual system does not apply automatically to marriages out of community of property in South Africa. For the accrual system to apply, it must be made provision for in the drafting of the actual antenuptial contract. The accrual incorporates a calculation that is applied to marriages so that once they are dissolved, either by divorce or by death, this calculation will determine what each spouse, whether they are alive or otherwise, will ultimately walk away from the marriage with. Upon the dissolution of a marriage in community of property, on the other hand, should the marriage come to conclusion by way of divorce, the balance of the joint estate after all the liabilities have been settled must be divided equally between the spouses. Of course, Section 7.1 of the Divorce Act makes provision for the parties to agree on the division of the joint estate in any way that they believe suits them. In the instance where the parties cannot agree on how their joint estate is to be divided, a prayer for the appointment of a receiver or a liquidator to divide the joint estates may be included in the divorce summons when it has been served. We then look at what does this look like when we discuss trust. So what does your marital regime look like, and how does this incorporate it into the bigger scope of trust? A trust, like Jacques has said previously, may be used to hold and protect personal or business assets, as mentioned earlier, which is especially beneficial in the event of subsequent liquidation, sequestration, and of course, divorce. Although this is the position in our law, this does not mean that the trust property is entirely excluded where divorce proceedings are taking place for the calculation of the accrual. In many cases, which we'll speak about shortly, the courts have held that one of the factors which a court may consider is that certain substantial assets were held in trust by one of the parties who simply used that trust as his or her alter ego. Generally speaking, assets held in a trust are separate from the founder and the trustee as per the Trust Property Controls Act, and the reason why most persons want trusts to be created. However, during a divorce, courts can scrutinize the purpose and the administration of a trust, especially if it was established during the marriage or if one of the spouses controls their trust. If the court finds that a trust was used to manipulate or hide assets, which we do find happens from time to time, it may include those assets in the division of the matrimonial property or the calculation of the accrual claim. This principle allows courts to disregard the separation, which essentially is enforced by the Trust Property Controls Act, between the trust and that specific spouse or the spouse in question, treating the trust assets as if they were part of the spouse's personal estate. And this is where that piercing ultimately takes place. If the courts find that there was evidence, firstly, of misuse of that trust, so if that spouse were, or if that trust was used to avoid paying debts or to protect assets from the spouse's claim. So, for instance, if property was specifically put in that trust so that one of the spouses couldn't get their hands on it on divorce, the courts can pierce that veil. If it is proven that that spouse had de facto control over the assets, insofar as if one spouse had effective control over the trust, even if they were not the trustee or the beneficiary, but they were using the trust to operate their businesses. And we'll go into that a bit further when we look at the case law. And then, of course, one that Jacques mentioned earlier was the alter ego trust. If the trust was used as a mere extension of that spouse's personal affairs or business, so they just operated the trust as if the trust belonged to them or their own little personal bank account. And a lot of people have this misconception that because they created the trust and they have funded the trust, that asset belongs to them, even though it is held in trust. And that is where the separation ultimately needs to take place. So what we will do shortly is now look at the different case laws where this is concerned. Jacques?
Thanks, Kelly. I think the first case that I want to look at is, to my mind, probably the classic case, and it was decided here in the Western Cape, if I'm not mistaken. Judge Traverso was the judge in the case, is Jordan versus Jordan. And this is a marriage that was concluded prior to out of community of property prior to 1984. So the provisions of Section 7, subsection 3 of the Divorce Act applied to this. Mr. Jordan was a very successful businessman. He built up a large estate during the marriage. And he then created several trusts. I think there were 4 or 5 trusts at the end of the day. The plaintiff, in this case, Mrs. Jordan, stayed at home and she cared for the children. After the marriage, she asked for a distribution order in terms of the Divorce Act, and the court had to decide whether it could take the assets in the trusts into account when determining the value of Mr. Jordan's estate and the value of the distribution order that they could make. Mr. Jordan, of course, argued that because of the limitation that the trust deed and the Trust Property Control Act imposed on his acts, the assets of the trust should not be regarded. Now, the court then found on the facts, and I think that's one thing that perhaps we just need to stress here, Kelly, is that a lot of these cases turn on the facts. And there are 1 or 2 cases where the court held, for instance, that yes, there was a trust, there was a valid trust formed, and yes, the person may have interfered with the assets to a certain extent, but the plaintiff or the defendant did not present enough evidence to say that it was done with the intention of defrauding the other party to the marriage. But in Mr. Jordan's case, we had the situation where Mr. Jordan concluded a so-called letter of wishes. You all will be familiar with that, those of you who have trusts, which stated inter alia that at all times he had access to the capital of the trust. There were tremendous amounts of money flowing between the trusts without any resolutions, without the defendant, who was one of the trustees, ever being involved in it. And he would then just give instructions for the money to flow. No book entries were made to document the flow of money between the trusts. Financial statements reflected loans in many cases to the children. No records were kept, no resolutions of that. And then also the statements, the financial statements of the trusts were structured in such a way that Mr. Jordaan's income was reduced. And the court held that at the end of the day, yes, there were valid trusts. The trusts were validly constituted, but the way in which Mr. Jordaan used the trust constituted this trust his alter ego, and that the assets in the trust and their value must be taken into account when determining the value of the Jordaan's estate, firstly, and secondly, the order that the court could make in terms of Section 7, subsection 3 of the Divorce Act. And here the court quite clearly said, yes, we can pierce this veil and we can take the trust assets into account when making our decisions on the distribution. Kelly?
Thanks so much for that, Jacques. Another case that often comes up in this conversation is Badenhorst versus Badenhorst. And in this one, we have a matter where Mr. Badenhorst instituted the divorce proceedings. And so his spouse then lodged a counterclaim for the redistribution of assets. And what then took place was that the Supreme Court of Appeal found that just because assets vest in a trustee does not mean that it cannot form part of, in this instance, the husband's estate. However, the court said before we actually go and do this redistribution, there needs to be proof submitted that Mr. Badenhorst controlled the trust as if it was his own, and that if it was not for the intervention of that trust, he would have owned the assets in his personal capacity. In order to determine this, the court had to first peruse the trust deed to see what provisions did it make insofar as his powers were concerned, and secondly, how were the assets of that trust administered. And the way in which they done that is they ascertained that firstly he was one of two trustees, and that he did not need the authorization of the other trustee when making specific decisions. He utilized the trust for his business purposes and made no distinction between his own assets and that of the assets of the trust. As the founder of the trust, further, he was empowered to vary the provisions of the trust deed and could remove and appoint trustees as he wished. These factors led to the court to believe that he was in full de facto control of the trust, and as a result, they ordered the redistribution of the accrual assets to include that of the trust. They further took into consideration that there was a farm that was acquired during this time, which significantly increased the trust assets, and of course, his own personal funds were used to increase the asset value of the trust. So that's a clear distinction where the court said, look, we are looking at the trust assets because there is no way that this specific individual was not using the trust as if the trust assets were not his own. However, on the inverse, or on the opposite side of that, we have another court case, MJK versus IIK, where they try to base the arguments on a very on a similar basis of that of Badenhorst, where the respondent in this matter had alleged that her husband had used three trusts as if they were his own, as well as a close cooperation. And the reasoning for this was that there was no distinction between her husband's income and expenses and that of the trust and the close cooperation. She further told the court that he had control over who was trustees, and that he named his friend as a trustee, who was just simply a trustee in name, but didn't really make any independent decisions. She further went on to say that the control and the management of the trust was done solely by her husband, and that the CC as well. Her other reasonings were that there was no meetings of trustees, that the trust deeds of the three different trusts specifically gave her husband a wide range of power over the management of the trust as well as the close cooperation. And lastly, she had raised that the trust funds and the assets in the trust was specifically removed from his personal estates and put into trust as a way of prejudicing her from later claiming any the accrual that she was entitled to should their marriage have dissolved. And the courts took a hard look at this and they said, look, it was misplaced to use the argument used in Blignaut. And the reasoning for this is that her husband came forth and said she was very much aware of the fact that there was estate planning. We see this often when persons come and want to plan their wills, and the idea of removing certain assets out of your estate and putting it into trust in order to reduce the value of your estate often comes up in conversation. And so this is what took place in this instance. It was the trusts being created were used as an estate planning tool, and not so much to fraudulently move any assets about. And she was party to this, and so she did not oppose that the trusts were used for those purposes. The courts carried on and looked at who were the beneficiaries and what were the objectives of this trust. And the objectives of the trust was ultimately to protect the assets and to ensure that both the husband, the wife in this instance, and the children, one being mentally challenged, were protected and did have these assets at their disposal. The respondents and their two children were also capital beneficiaries of that trust. So ultimately, she would have benefited from that trust regardless, and so would her children. The courts or the Supreme Court of Appeal further found that there was no evidence that the trust or the close cooperation were used as the alter ego of the appellant in this matter, and that there was no evidence that those assets were moved to prejudice the respondent in this matter or to fraudulently move an asset that she couldn't claim from it. It was simply used as an estate planning mechanism to which she would still benefit from. And for those purposes, the court found that they could not necessarily pierce that trust veil because all the evidence pointed that there wasn't an ulterior motive in this case. Back to you, Jacques.
Thanks, Kelly. Kelly, if I may, countrywide, for those people who will not find the case of Badenhorst, it's in fact Badenhorst.
Here we go. It's the missing the Afrikaans parts of it, Jacques. I must apologize.
But anyway, if we could carry on, there's a further case decided more or less in the Supreme Court of Appeal at more or less the same time as the last case that Kelly mentioned, MJK versus IIK, and that is PAF versus SCF. And I think this case illustrates the contrast with the case that Kelly discussed. Here, the husband formed a trust once the parties were getting close to divorce, and the trust was formed in the Isle of Man, and the only beneficiary was the party's daughter, and there was obviously an independent trustee. But simultaneously with that, the husband who formed the trust, most cases the husbands are the culprits here, he paid, I think he settled about £115,000 in the trust, but he also paid £125,000 to his dad, ostensibly as repayment of a loan. The KZN High Court found that these transactions were fraudulent and performed with the intent of defrauding the wife, and that they could actually peer the trust veil and get to the assets and the values. Mr. F abandoned his defense on the claim of the payment to his father on appeal, and only said that the trust was formed with estate planning purposes, and accordingly the assets could not be taken into account. The court held one or two very interesting things, because this was also an accrual claim. So the court here said that yes, the other courts that said that there's a very limited discretion for the courts in terms of the Matrimonial Property Act to pierce the corporate veil, but the court said the authority that the court has to pierce the veil is a common law authority and is not necessarily derived from the wording of a statute. So the court has the authority, even in accrual claims, to go behind the veil of a trust or a company to look at the assets there and the value of the assets. However, the court held that that is an extraordinary remedy that must be exercised with circumspection. However, in this case, the court also then held at the end of the day that the way in which Mr. F had structured the trust, moved the money out there, and I think probably simultaneously with the way in which he dealt with a sham loan to his father, the court held that in this case, it wasn't proper estate planning, and that they could look behind the veneer of the trust because they felt that there was an intention to defraud. So when we get to the remedies a little bit later, this is one aspect that one must take into account. If you're going to do estate planning using a trust, start early, not the moment your spouse serves the summons for divorce. That is slightly late. Kelly, I think that's the cases, if I'm not mistaken.
That is correct, Jacques. We're now going to look at estate duty.
Yeah. Kelly will just talk a little bit about the Estate Duty Act and how the trust personality can be disregarded there.
So what we find in the State's Department is that often people come forward and they're wanting to create trusts for the estate to navigate estate duty. For those of you that don't know what estate duty is, it's a tax that is paid on assets that are bequeathed to specific persons as per your will in terms of intestacy. Other countries refer to it as inheritance tax, but it's tax in the hands of the deceased estate as opposed to in the hands of the beneficiaries. And so often trusts are used as a way to decrease people's estates, and so it's used therefore in estate planning circumstances. However, assets of a trust can in certain circumstances be deemed to be that of the deceased in terms of Section 3, subsection 3 of the Estates Duties Act. This section deems property to be that of the deceased if immediately prior to the death, he or she was deemed or competent to dispose of of the asset for his or her own benefit or for the benefit of his or her own estate. And a person is competent to dispose of any property if he or she had the power to appropriate or dispose of such property as he or she saw fit, whether exercisable by will, power of appointment, or any other manner, or if under any deed of donation, settlement, or trust, or any other disposition made by him, he retained the power to revoke or vary provision thereof relating to such property. So what I am finding quite often is that people want to dispose of when doing their estate planning and they're drafting their will specifically. They're mentioning the trust assets in their will. And that is a simple or the easiest way for SARS to pierce what we call this trust veil. Because why is it that you are wanting to dispose of assets in your will, but on the behalf of the trust? There is clear signs that you're using this trust as an alter ego or an extension of yourself. If the founder or the person who's controlling this trust has the power to appoint and remove trustees at their will, that is a clear indication that this trust is again being used either as a sham or an alter ego. And so SARS can then say, look, yes, the trust is or the assets are owned in the name of the trust. However, for state duty purposes, we are going to calculate whatever assets are in that trust to form part of your estate for the ultimate taxes that will then be paid to us. And so, in order to avoid all of that, Jacques will tell you a little bit further on how do we navigate the trust veil in order to keep it so that no one can then have the power or the authority to pierce it.
Kelly, just to make clear, the in the estate duty, and correct me if I'm wrong, it doesn't mean that SARS will go after the assets. It just means that the value of the assets will be taken into account in determining estate duty in the estate. And obviously, if there aren't enough assets in the estate then to pay the estate duty, you could end up having to dispose of some of the trust assets and distributing it back into the estate.
Absolutely correct. Absolutely correct. SARS will just look at the value. So they won't necessarily do anything with those trust assets, but they'll just look at the value. But if, like you said, there is a cash shortfall in that estate to cover the cost of the liabilities, the trust assets may need to be sold in order to fund the shortfall.
Okay, thank you very much. Now, I think if one looks back on what we said this morning and we look at the principles we can from what the courts have said, I think the intention of the parties would be important. If we look at the last two cases we discussed, in the one there was a serious intention of estate planning backed up by the facts. The second one, there was an allegation of estate planning, but it's clear that the ultimate intention was to abuse the corporate personality of a trust. Similarly, in the Jordan case, the court found that Mr. Jordan's intention may not have been to totally divest himself of control of the assets. And I think if one wants to look at how you can guard against the separate personality of a trust being set aside, we can look at it from the point of view of a sham trust and also from the point of view of the alter ego concept that the courts have developed. But keep in mind that in the case of both a sham trust and an alter ego, whoever wants to get to the trust assets will have to allege and prove in their pleadings all the facts necessary to sustain their case. In the case of a sham trust, they're going to have to prove that there wasn't a trust. So they'll have, because they're the plaintiffs or the claimants in that case, and the onus to prove that would rest on them. And similarly, if you want to rely on the doctrine of the alter ego, you're going to have to present the court with all the facts that will sustain your claim. If, on the other hand, you are the party that's at the receiving end of a claim, how could you have protected yourself? And if you are forming a trust, how must you protect yourself? In our view, that starts with the first document, namely the drawing of the trust deed. And in drafting the trust deed, the draftsman must take care that you don't reserve unnecessary powers for any of the parties to the trust. So don't have powers reserved for the donor that will override the trustees. Do not give one trustee too much power. So, those are things you need to discuss. Also, when the trust is appointed or the trustees are appointed, take great care in the appointment of the independent trustee, because as you all know, after the Parker decision, the Trust Property Control Act was amended to provide that all business trusts, which are basically family trusts, must have an independent trustee. So take great care in selecting your independent trustee, and don't give the donor or the donor who's also a trustee the right to override the independent trustee, because clearly that would be contrary to what is needed. Now, in a sham trust, you remember that we said the courts held that a sham trust, the trust doesn't really exist. So once again, when we get back to the drafting of the trust deed, make sure that the trust deed the trust has either an object or a beneficiary. A trust without an object or a beneficiary is not a trust. So that trust would never come into existence. Secondly, make sure if the trust deed requires the donor or any party to the trust to do something to establish the trust. For instance, paying over money into a bank account or transferring an asset, that must be done. If it's not done, then similarly, there's a good chance that the trust may not have properly come into existence. As an example here, you can look at the Close Corporations Act, which specifically provides that if the initial contributions of members aren't paid into the corporation's bank account, and until such time as it is paid, the members are personally liable for the debts of the corporation. Then also a sham trust, and this overlaps with the alter ego concept, the administration of the trust. If that is shocking and probably non-existent, one can probably conclude that even though a trust deed may have been properly signed and trustees appointed, that the trust never came into being because of the way in which it was administered. Now, moving away from sham trust concept into the alter ego concept, remember that the courts have held here that if a trust is somebody's alter ego, there is a valid trust. So how does one protect the valid trust veil from being pierced in cases where somebody is alleging that the trust is in fact an alter ego? I think once again, same as we said with the sham trust, do not reserve, it starts with the drafting of the trustee. Do not reserve unnecessary powers for trustees or specific people. And once again, the choice of the independent trustee. You need to divest yourself as a donor of the ownership of the assets, and you need to trust those trustees, which probably will be yourself as donor and maybe your spouse and the independent trustees, that they will manage the trust assets for the benefit of the beneficiary. But that needs to be your intention, and that must be clear from the document that you draft. And then I think very, very important is ensure that the management of the trust complies with, firstly, the requirements of the trust deed, but secondly, corporate governance and the provisions of the Trust Property Control Act. Ensure that if meetings are called, proper notice is given. Ensure that minutes of meetings are kept. Ensure that if resolutions are passed, they are reduced to writing, recorded in the minute books, and adopted as minutes at the next meeting. So and involve all the trustees in that. And especially family trust, where you have that the spouses being trustees. Perhaps I'm speaking to the men here who seem to be the culprits in all the court cases. Involve your spouse in the decision making and the run of the trust. It serves two purposes. On the one hand, it shows that the trust is being run properly in accordance with the trust deed and the Trust Property Control Act. Secondly, it deprives the other spouse of the ability to allege in court papers that he or she did not know what was happening in the trust and that he or she was being excluded from the decision making in the trust. So that's very important. I think if one looks at the revenue authorities, important, ensure that the trust's tax affairs are in order. And these days, the ultimate beneficial owner register, ensure that that is done properly and recorded with the master. And then finally, if I can end up on this, on a deathly note, do not try and rule from the grave. As Kelly said, do not put any provisions in your will which can create the impression or give anybody the ability to conclude that the trust assets are in fact being managed by you. And that can be any provision which actually deals with assets that are in the trust, or alternatively, trying to appoint trustees that will do your bidding after your death. I think that's a red flag, and it's one that the revenue authorities are going to look at more and more going forward. And especially, I mean, if you think that spouses may be disgruntled or beneficiaries may be disgruntled in an estate, they may very well go after provisions like that in a will to challenge the separate personality of a trust. And then finally, and I know a lot of us do it, I've done it for clients, I've done it for myself, avoid letters of wishes. Letters of wishes are not binding on trustees, and trustees may very well even be breaching their fiduciary duty if they act in terms of letters of wishes that contradict specific or explicit terms in a trust deed. But that is once again just another way of trying to rule from the grave, or even during your lifetime, as in the Jordan case, where Mr. Jordan had a letter of wishes allowing him access to the trust capital. So, ladies and gentlemen, I think, oh my goodness, we've gone over time. Thank you very much for joining us. Thank you very much for listening to us. I trust that we've given you something to think about and some pointers on how to manage your trust affairs to avoid those assets ending up back in your own name, alternatively in the hands of your creditors, which you don't want, or even worse, in the hands of the South African Revenue Services. Thank you very much for listening to us, Kelly. Thank you very much. I think we're over time, so if there are any questions that were sent through, we'll try and deal with them and revert back to you as quickly as possible. Thank you very much. Have a nice day.